Hello everybody, welcome back to the channel for another banger. So as you can see by the title, I'm going to be going over the lawsuit that SOS is in. So I'm going to give you a little bit of background before I get into it. Then I will read some of the court docket, and I do have a legal background. So we're just gonna do that today, and I'm gonna give my 2 cents about it. Yeah, hopefully this is fun for me and you. But before we get into that, don't forget to click that subscribe button, as it helps the channel out and keeps me motivated to post videos, and like, comment, do all that good stuff. Do all that good stuff before we get into it, because it's probably gonna be juicy. Okay, I always find lawsuits juicy. Okay, so let's get into it. So a little bit of background on this is that SOS is essentially being sued by Beltran due to the fact that they fabricated a merger with a supposed Canadian crypto firm and lied to investors about its mining operations in order to inflate its stock price. Yikes, y'all. That sounds so juicy, y'all. Okay, yeah. Let me just stop with the juicy stuff, but it seems hot. Like, this seems hot. Like, y'all, my biggest pet peeve is companies that just make up shit. Okay, pardon my unprofessional language, but it's like, why? Like, why can't you work hard like the rest of everybody? Anyways, so yeah, so that's what the classic action is basically about, and we're going to get into the court docket. So the first one that I'm going to go through is the one on the 9th of December 2021. So the lawsuit is basically happening in the United States District Court for the District of New Jersey. Okay, so it's about from Kimberly Beltran individually and on behalf of all other similarly situated plaintiff versus SOS Limited, Yandai Wang and Eric H. Wan, who are the defendants. So class action, order granting joint scheduling stipulation. So this matter having been brought before the court by way of a joint scheduling stipulation. So what that means is it's basically like a joint submission. Filed by SOS Limited, Yang Wang and Eric H., collectively defendants with consent from the lead plaintiffs Sho Ho and William Rogers. By and through the parties resolve respective counsel for an order granting the stipulated schedule for the filing of an amended complaint. So basically both of them, in simple terms, are both filing so that they can amend what the complaint is. So SOS is also asking for a motion to dismiss. So what a motion to dismiss is literally what it's a motion to dismiss. So a motion to dismiss the case, basically throw the case out because it has no grounds or there are no grounds. Now, usually in civil procedures, stuff like this, there's no proving things beyond a reasonable doubt. It's kind of like, it doesn't have to be proven. And the onus is obviously not on the court because it is between two parties. So the onus is on both of them to prove what their case essentially is. So a motion to dismiss, an opposition to the motion to dismiss, and a reply in support of the motion to dismiss, and the court having considered the party submissions for good cause shown. It is on this 9th day of December 2021 ordered that the parties' joint scheduling stipulation is hereby granted. So what this means that on 9th of December, SOS and Kimberly Beltran were both granted the joint scheduling stipulation, and they also ordered that the defendants are not required to answer, move, or otherwise respond to the current complaint in this action. So what this means is that SOS is not required to respond to the initial complaint, and then they further ordered the plaintiff shall file an amended complaint or else notify the court of their intention not to file an amended complaint on or before February 18th, 2022. that's pretty self-explanatory. So they also order that the defendant shall answer or otherwise respond to the amended complaint or to the current complaint if plaintiffs elect not to amend it on or before April 8th, 2022. Now, in simpler terms, this means that Kimberly Beltran, okay, are being given until April 8th, 2022 to amend their complaint, so their initial complaint, since they were both awarded the opportunity to do a joint scheduling. So that means SOS shall answer or otherwise respond to the amended complaint or to the current complaint. So SOS can respond to the old one or the new one if the plaintiffs say, you know what, I don't want to do the joint scheduling. I don't want to submit anything else. Like, I'm keeping what I said is what I said. So then SOS can respond to the new one or the old one. And if the plaintiff, which is Beltran, chooses not to, then SOS is required to respond to the old one before April 8th, 2022. They also order that if the defendants file a motion to dismiss, plaintiff shall file any opposition thereto on or before June 3rd. What this means is, if SOS files a motion to dismiss, essentially filing to dismiss the case, then Beltran shall file any opposition to that. So if Beltran is like, no, like, we can dismiss this, they have to file that before June 3rd, 2022. If they do not, the logical conclusion is that SOS will get the case dismissed, if that makes any sense. Also, they order that the defendant shall file any reply in support of the motion to dismiss on or before July 6, 2022. Okay, so SOS, who are the defendants, have to file their reply in support of the motion to dismiss on or before July 6th. You can't do July 7th, okay, because then they'll rule in the favor of the other party. They also order that pending the determination of any motion to dismiss by defendants, no status conference shall be held. No status report shall be required to be filed, and pursuant to the Private Securities Litigation Reform Act of 1995, 15 USC. Guys, I do not know how to cite American law yet. Give me 1 year. But, so I can't do that for you. So no discovery or other proceedings shall take place unless and until the court finds upon the motion of any party that particularized discovery is necessary to preserve evidence or to prevent undue prejudice to that party. Now, that was a mouthful, and I'm going to explain what it means. I'm going to go over it slowly, okay? So, basically, as of right now, the courts are pending the determination of any motion to dismiss by the defendant. Thus, SOS is waiting for their motion to be dismissed, okay? Now, as they are in waiting, there shall be no conference held. There shall be no status reports required for them to file. And the reason they got this is due to the Private Securities Litigation Reform Act of 1995, right? And no other discovery or other proceeding shall take place. So you can't be like, oh, I found something else that they did. No. Unless and until the court finds upon the motion of any party that particularized discovery is necessary. So the only way that any proceedings will be happening in this case is if there is a need to preserve evidence, is if not going forward with any proceedings, so not discovering is going to cause either party, or is going to cause evidence to be messed with, or it's going to prevent undue prejudice to that party. So the only way that there's going to be any sort of proceeding is if they have to preserve the evidence, or if not going forward with that proceeding, so not going forward with this, is going to cause prejudice to a party. I tried my best to explain that. It was a mouthful. But yeah, so this is that court docket, which was filed on December 9th, 2021. And yeah, that's all for this video. I kind of need a water break, and yeah, we'll go over the next court documents in the next few videos. So yeah, y'all let me know what you think. Did you understand what I said? Did I just not explain it properly? or what you guys think about this. So yeah, you guys let me know what you think, and I'll see you in my next video. Don't forget to smash that like button, smash it, okay? Like, comment, and yeah, see you in my next video. Bye.